Hi, everyone. This is Gayathree, and I'm an MPhil candidate at the University of Oxford. I'm really thankful to the organizers of the DLL Ansal University Moot, firstly for organizing this Moot during these testing times, and also for reaching out to me to do this session on mooting for all of you. Mooting has been my pet passion since my first year at law school back in India. Although I did not really give it much thought when I first started mooting in law school, um, I really think it has a lot of real world value for all students. You might think that, oh, this is such an intensive exercise and it involves a lot of investment of time and effort on your end, but trust me, it all really does pay off. Um, so I think at its very essence, mooting is the art of persuasion. So you're basically trying to convince a judge that your line of argumentation and that your understanding of the case is the right way to look at things. And that is a skill that you benefit from having at any workplace, not just a legal workplace. And apart from that, as advocates and lawyers, I guess moots also help you learn so much about a specific area of law and introduce you to very nuanced debates in that specific area of law. And as someone who has benefited from that experience, specifically in public international law, because much of what I learned in my 5 years at law school about public international law was through moots, and that's really, really benefited me right now in Oxford. So I would encourage all of you to look at mooting not as merely an exercise that helps you put something into your CV, but as a really important learning curve in your life. So that said, I think I'm going to jump right into the questions that the organizers have forwarded to me. These are your questions. Um, so the first question is, how many minimum case laws should one have in his memorial and how to find the relevant ones? What about those case laws which weaken our stand and should we mention them too? Um, I honestly don't think that there is a minimum number of case laws you should be having in your memorial. But as a general rule of thumb, I would advise you to remember that what's important is that you include a case law for every legal position that you are articulating in your memorial, right? So sometimes you are able to lay down the law just by looking at a legislation, but most other times you will have to interpret that legislation in a certain way in order to arrive at a particular conclusion about the law, right? And that's what the courts do for you through their case law. So, every point of law should ideally be cited with the help of a case law. How do you find the relevant ones? So I think that the trick basically is to identify certain keywords which help you um, extract the particular position of law that you need from a case. So maybe you are trying to look for a case law which talks about how the limitations to the right of freedom of speech have been interpreted by the Supreme Court of India. So you go to Manupatra or you go to SEC online and you type out precisely these keywords, right? Like you type out freedom of speech, or you type out free speech, and then you type out limitations, Supreme Court of India, and then you look at the list of cases that come out. I guess it's ultimately a matter of reading exactly what each case has laid down in order to glean whether it's a relevant case or not, and figuring out whether it actually says exactly what you want it to say or not. Obviously, this exercise does not really require you to, look into the facts at length. So you start off by looking at whether the position of law that you want to articulate in your memorial is there in this case or not. And once you think that that's what the case is saying, you can read it in greater detail and understand the facts of the case and how the law was applied to those facts, etc. Um, but another advice that I have for you is that what I found really useful, especially while researching domestic case law, was to just directly type these keywords on Google in double quotes. And also towards the end, just type Indian Qanun in double quotes, right? So because for a very, very basic level of research, you can definitely use Indian Qanun and figure out if a case is actually saying what you want it to say, and then go to SEC Online and download the case and read it in greater detail. I think that's completely all right. What about those case laws which weaken our stand? Should we mention them too? If it's on a point of law that's very obviously debated, then in that case, I think judges will see it as a limitation if you don't refer to this case that is weakening your stand, right? Or is exactly the opposite of what you think is the right way of looking at things. But you mention it not because you're just trying to cover bases, but because you want to say that that case should not be relied upon by the court. So you will also have to provide a reasoning as to why the court should not be looking at this particular case that is actually weakening your stand. And you can do that largely by differentiating that case from your case on the basis of facts, right? And that is generally something that a lot of judges appreciate. So yeah, but be careful, because you don't have to include cases that weaken your stand if they are not a big deal, include only those that are very obvious that any judge would know and would question you on, because then it's going to be considered as a smart move that you address this question at the outset itself. Yeah, I think that's about it. The second question, how do you keep your research so exhaustive that no stone remains unturned? Any guidance on the sources to get a specific route for further research? I think in the case of domestic law research, you should be covering all bases if you look at legislations, case law, as well as any executive directives and regulations on that specific matter. So very often when you look at legislations, you realize that on various points, they basically defer to the judgment of the executive and say, you know what, on this particular point, we are happy for the executive to come up with its own set of regulations, its own set of rules, its own set of directives, its own set of guidance, etc. Right? And in case your case is actually reliant upon those directives that are made by the executive, then it's obviously very important that you look at those directives as well. Yeah, I guess it'll ultimately depend on how well you have read your facts, because your facts will always give you enough clues that lead you to the specific kinds of legislations that you're supposed to look at, the kinds of case law that you're supposed to look at, as well as the kinds of executive material that you're supposed to look at. I would also advise you to generally look at blogs, especially if your moot is on constitutional law. Then there are so many Indian constitutional law blogs and even journals that deal with a lot of nuanced issues in Indian constitutional law. So if you think that reading a case is not really helping you understand exactly what the court is trying to say, or is not really able to or is not really helping you understand like what the nuanced debate around that particular matter is, then I would advise you to also look at blog posts as well as journal articles to figure out exactly what the debate on that particular point of law is. And it's definitely okay for you to cite journal articles, though some judges do not really like to see blog posts. being cited in memorials. But to be really frank with you, blog posts these days are really, really laying out the nuances of law much better than most journal articles are. So I guess it's a gamble, but yeah, if you want to be completely exhaustive in your research, then these are all the bases you should be touching. And you just have to Google this, like blog posts are not that easy, difficult to locate. Okay, then we go to the third question: how to work and develop better speaking skills for oral rounds if one experiences stage fright. Um, yeah, I mean, to be honest, it's completely normal for you to be nervous going into a moot. But I think what really, really, really helps you with the nerves is practicing several times before the moot. Now, your practice sessions can definitely vary depending on how comfortable you are speaking in front of other people. Maybe for starters, what you can do is practice by yourself. Just stand in front of a mirror once you have your speech in place and just learn by heart, or maybe prepare like a list with like the exact points of law that you're supposed to articulate, the exact structure of argumentation that you have in mind, and then just speak to yourself. Consider yourself as the judge and just argue with yourself. um, but it's obviously definitely important to present these rounds before other people as well, because you need to test whether you are actually persuading others, that is, convincing others that your stance is correct. You need to figure out if you're able to answer questions that other people have in the course of you persuading them that your answers are correct, right? So in case you're not comfortable going up to like a senior in law school and asking them to like practice around with you, perhaps what you could do is first practice with your friends. Just say, hey, you know what, I'm doing this moot, I just want to test my arguments, like just tell me if you can understand what's happening, right? It's not necessary for your friend to be like an expert in that specific area of law, because more often than not, it's really, really the case where a lot of your judges don't really understand the nuances in the law as well as you as a participant do. So it's also a matter of like being able to explain to a lay person that this is the law and this is how you should be deciding the case. And your friends who may not necessarily be experts in the area of law will definitely help you do that better, right? And they can definitely give you advice on whether your pace is good, whether you're speaking loudly or not, whether you're able to manage your time well or not, stuff like that as well. So practice with your friends, and it's always, always, always a very good idea to practice with somebody who knows that area of law really, really well, because they will be in a position to ask you really, really nuanced questions on the law. And I think this is particularly important, especially when you progress into, progress through the competition and like reach the quarterfinals, semifinals, or the finals, where I think you tend to have people who know that area of law much better than most others. Yeah, so I guess practice makes you perfect. Now, the fourth question: if the counsel does not know an answer to the judge's questions, what is the best way to deal with it? I know that in law school, you are often told that you can plead ignorance and escape from such a situation, but you need not necessarily articulate it like that. Like, you don't have to say the counsel pleads ignorance. You can just say, Your Excellency, on this occasion, I'm not able to help you with that question. You don't have to phrase it in formal terms, is what I'm trying to say. But more often than not, I guess, although you may not have an answer to the exact question that the judge is asking, you may have an answer that kind of hits at what the judge is asking you. So you can try explaining that to the judge and like help them understand that, okay, I may not have the exact answer that you're asking, but perhaps this is what you're getting at. So this case definitely goes in that direction. And therefore, I think this case definitely favors my case. That's one way of putting it. Um, yeah, I guess that's the best way of dealing with it. And if you think that your co-counsel has an answer for the judge's question, then you can say, Your Excellency, I understand, or like, Your Lordship, I understand. And then just say, you know what, my co-counsel has dealt with this particular issue and will be able to guide you better once my co-counsel comes here to articulate his or her stance on other issues. Yeah, that's it. Fifth question, what is the best practice to prepare for the oral rounds? The best practice is just to keep practicing with whoever, how many ever times you can. Honestly, the art of persuasion is something that you develop only by practicing with different kinds of people. Because as you will see in a moot court competition, some judges are very invested in your case and will ask you a lot of questions, and they want to know more, they want to test your knowledge and all of that. Whereas some judges are very passive, they just want to hear you and see whether you are speaking well and you have a good structure of argumentation or not. Sometimes judges are rude, other judges are very calm and polite. So you have like a multitude of people sitting there and judging you, right? So it's very good for you to experience that before you go into a round. So just go walk up to your friends. If you know that one of your friends is like very rude in the way they, gets very personal when they realize that a particular legal argument doesn't really align with what they think the law should be, it's a very good idea to go and give them your rounds, because you never know, you may have a judge like that in your moot court competition. So practice to yourself as many times as you want to. Practice with your friends, practice with your seniors, practice with people you know are experts in the law. Now, when I say experts, I don't really mean like real senior advocates who are working on constitutional law. No, that's taking it too far. But like basically, maybe people who have just graduated from your university that you know are practicing constitutional law. So you go up to them and say, hey, so I have this moot. Do you think you could listen to me speak? And I'm sure most of them will be more than willing to help you. Yeah, I think that's the best practice. And like another important thing that you need to keep in mind is that the entire idea of practicing so much is to ensure that you're able to figure out how your speech should evolve, how your speech should change and cater to the requirements of each bench, right? So once you figure this out, I guess, and walk into the courtroom, the mock courtroom, you need to be able to gauge the bench. You need to figure out if this is a bench that asks a lot of questions or if it's a bench that does not ask a lot of questions, because based on that, you will also be able to decide on how well you're able to manage time. You can make a decision on whether you will be able to address every single argument that you have penned down, or if you will be able to address only a few of those arguments, right? So yeah, practice really helps before oral rounds, and practice as much as you can. The sixth question is how to improve oratory skills while going for international moots. Is the coach necessary while preparing for big international moots like Jessup, Stetson? How to know that your research is going on in the right direction or not? There's no real set way of improving your oratory skills while going for international rounds, I guess. But what really helped me was to watch videos of these international moots and get a sense of the kind of style that all these oralists adopt in their speeches, and then try to incorporate that style into your speech, into your own speech, and then practice with someone, right? Because yeah, and that's the only way you can go about things. If you want to improve the way you present your arguments, you practice with as many different kinds of people as you can, because that's what you will be presented with at the end of the day. As for whether a coach is necessary for preparing for these moots, in my experience, it's really, really good to have a coach who has an understanding of the law, only because very often your understanding of the law or of a certain way of arguing the case will benefit from somebody's advice, especially if that person has done similar moots in the past or is an expert in their area of law. Because if you are practicing in that area of law, you are bound to know more minute elements of that law as compared to a law student who has just started learning that law, right? So yeah, I think it's definitely useful to have a coach, especially if that person has done one of these international law moots. One of these international moots, because they will be in a position to tell you exactly what judges in international rounds expect of you. Because that sometimes tends to vary from what domestic judges expect. In my experience, domestic judges tend to question more than a lot of international rounds judges, who are more interested in seeing whether you have a good structure of argumentation. And especially if you have progressed through the competition to one of the advanced rounds, then you will have judges at the international level who are looking for more nuanced argumentation than you do at like the domestic level at the preliminary rounds. So yeah, it's good. It's definitely good to have a coach with experience. How do you know that your research is going on in the right direction or not? Like, if you have a coach, I guess they will tell you whether your research is going on in the right direction or not. But honestly, just have faith in yourself. Like, you have been researching this particular mood problem for quite some time, right? So at some point or the other, you would have read something that is relevant to your mood. And it's just a matter of putting that into your memorial, into your speeches. That's all. Just have faith in yourself. Honestly, like, moots are not really that difficult. It's just a matter of figuring out the area of law and looking into it in greater depth and greater detail. That's all. Seventh question: can mooting be helpful for the people who want to pursue arbitration as a career? Certainly. Like I said to you in the beginning, mooting is primarily just the art of persuasion. So honestly, even if you're not pursuing arbitration or even law as a career in any workplace, knowing the skill of persuasion is really, really important. But setting that aside, to specifically talk about arbitration, there are several moots that deal with arbitration, both commercial arbitration as well as investment arbitration. So yeah, definitely. And especially when you look at some of these international moots on arbitration, they also give you a very, very extensive opportunity to network with other people and make connections, which will definitely benefit you in your career as well, right? To know people. So yeah, moots are definitely helpful that way, especially in arbitration, international moots. The eighth question: how to file a perfect compendium? um, yeah. So, I mean, I'm not sure if most moots really ask you to make a compendium, but it definitely reflects that you have taken this moot seriously and worked on it very diligently. So it's good to have a compendium. I guess what's most important about the compendium is that you are able to flag it out and number it really well. Because very often we tend to just print out whole cases and then like pile them together and bind them and give it to the judge. But that doesn't really help, right? Like if you are quoting a certain paragraph from a certain case, then it should be easy for that judge to go to that exact paragraph in your compendium. So, which is why I would advise someone who is interested in preparing a compendium to ensure that they highlight that particular paragraph in the case and also put like a post-it note next to it so that the judge is able to, turn over to that particular page with ease. And it's also important for you to tell in your speech that, like, okay, you have the compendium, please turn to post-it number 1, because that's where the case is, that's where this paragraph is, right? You don't have to keep referring to your compendium all the time, though, in the course of your speech. Just do it where a judge might really, really be interested in looking at the exact quotation in that particular case. If you're not quoting something directly from the case, then it's completely useless for you to waste time explaining to the judge that they should be looking at this certain page, waiting for them to turn to that page, and then articulate your argument, um, uh, yeah, I guess that's what you should be keeping in mind with respect to compendium, that the compendium is there to make things easy for the judge. So the compendium should be numbered perfectly, and it should have all these flags which make it really easy for the judge to understand what you're saying. The next question, the 9th one, is how to tackle a situation wherein a speaker has cited relevant authorities, but the bench is adamant to prove them wrong. Um, um, I mean, this has not really happened in my experience. No bench is ever adamant to prove someone wrong. But I guess what benches try to do is they try to tell you that we get your argument, but that's not what we are looking for. So more often than not, most moots generally have the organizers briefing the judges in advance on various points of law, like in consultation with the person who has drafted the moot problem, right? So there are specific arguments that these judges are looking for when they walk into that courtroom. And if you are not hitting those points, then they will ask you questions specifically to direct you towards the line of argumentation that the bench memorial or the drafter of the moot problem has recommended as the right way of arguing, right? So take their questions as a hint to move on to some other alternative argument that you have already prepared. Generally, that's what, if a judge is repeatedly saying that they are not convinced with a certain argument, generally that's what they are trying to do, that they are trying to lead you to an alternative argument which they think is more convincing, which they have been told is the right way of arguing, right? So yeah, you should be perceptive during your rounds, and yeah, take the hints that the judges are giving you. No judge is ever really adamant to prove you wrong unless you are actually wrong. Yeah. Then the 10th question, what does it take to be an excellent mooter? What does it take to win? Um, I don't want you to look at moots as something that you need to win. Please view them as a learning experience, because that's what they are meant to be. But I guess what it takes to be an excellent mooter, I guess, is very, very diligent preparation and practice. You need to be serious, I guess, when you are doing your research. You need to diligently organize your research in one place, because it just makes things easier throughout the course of your moot, including the oral rounds. Um, yeah, yeah. Any person who looks at a moot as a way to learn the law and really enjoys that whole experience of researching and doesn't view it as a burden is definitely an excellent mooter in their own right. Okay, so that actually brings me to the last question, which I can't see here. Just give me a minute. Okay, so the last question is, moot courts are often considered to be the preliminary step towards the art of practicing law. That's correct. How exactly does the moot help us in our individual growth and in our career in litigation and corporate fields? Um, okay, actually, that's not the last question. There is more. Okay, fine. So I'm just going to address that. I think I already did. I've told you that it really, what it tries to teach you is the art of persuasion. And that is definitely going to help you in any workplace, including a corporate law firm. Because very often you are put in a situation where you are supposed to explain a certain line of argumentation to your partner, right? And you need to be a persuasive person. And any person with like a structured line of thought is persuasive, I guess, at the end of the day. So that's what moots prepare you for. They make you inherently more confident, I think, in articulating your position. And they also help you learn the law, learn nuances in the law. Um, so if you are someone who is looking for a corporate job, then I think it's wise for you to do corporate law moots, because they will definitely give you a certain edge over others by introducing you to nuanced debates in that field. Similarly, if you're looking at litigation, then please look at moots that are, I guess, tuned to the certain area of law that you would like to litigate in. Like if it's constitutional law, do constitutional law moots. If it's corporate law, do corporate law moots. If it's tax law, do tax law moots. Yeah, it does introduce you to a lot of new contemporary debates in that area of law, and basically generates your interest in that area of law also. So yeah, I guess that's how moots help. And in your individual growth, like I said, they definitely make you more confident, because if you're standing in a courtroom and you make your argumentation and you win that round, that certainly is satisfying, isn't it? Like it does give you a sense of validation that oh yeah, I argued and somebody was happy with my argumentation, right? It does give you a personal sense of satisfaction. um, yeah, I guess that's about it. And now we are at the last question. Memorandum is regarded as the brain of the argument and is an indisputable element in a moot competition. What is the secret towards the drafting of a better memorial? Um, I guess, I mean, there's no secret really. You must all be familiar with this method of drafting that we call IRAC, right? So I guess following the IRAC method of drafting is really helpful. So each argument begins first with a statement of like the identified issue at hand, which will be followed by an explanation of the relevant rule of law applicable. Then the facts will be explored in light of this rule of law, leading to a concluding statement on that particular issue. Right. So following IRAC, basically what it does is it makes your argumentation very concise and yet very structured. And that's really important, because when stuff is like small and yet like says everything that you need to know, people who are reading that will be really happy, right? So yeah, I guess that's the secret to good memorial drafting. Other than that, I think it's also really important to make your memo look good. I know it sounds like I'm emphasizing a lot on appearance, but I think at a level it does matter, because if it's poorly formatted, somebody who's reading it may be like a little, oh, okay, this person clearly did not take their memorial seriously. That's why they didn't even invest time in like formatting it well and all of that. I mean, it could lead to that conclusion. So I think it's important for you to format it really well as well, in addition to, drafting it really well. It's always a good idea to run your first draft of the memorial past somebody else, just to see. And when I say somebody else, actually, I mean, if you have a coach, your coach, or somebody who is familiar with that law or has done a lot of moots, because they will be able to tell you if some sentence in your memorial does not make sense, or if there is any inconsistency in argumentations that you're raising on the different issues, or if there are any repetitions of the law, stuff like that. And they might also give you advice on how to make your arguments more concise, etc. So yeah, so it's good, always a good idea to run your memorials past somebody else. I think that brings us to the end of all your questions. I had the pleasure of writing something about how to deal with moots back when I was starting my 5th year in India. So I can potentially share that link with your organizers so they are able to send that to you. I think it addresses everything related to moots in great detail. So if that's helpful to you, I would like you to benefit from that. But other than that, like I said, please take moots as a learning experience. You're not there to win it. It really doesn't matter whether you win it or not. What matters, of course, is whether you walk out of that courtroom feeling as though you have done everything you could to convince the judge that yours was the right line of argumentation. That's all that matters. So yeah, stay strong and stay safe. And all the best for your online moot. I hope everyone has a great experience. Bye.